Welcome, everyone. This is class number 12 of the July 2023 Ibis Prep Florida Bar Crash Course. We're going to be doing real property, looking over Florida essays. I've always said that I think real property is the most difficult subject on the bar exam in general, meaning combined MBE and as an essay subject, and it's because it's all over the place. There's no real formula. I don't have a lens for like, this is how you attack a real property problem, or I don't have a backbone structure of write this every time you see real property. It really does come down to knowing a lot about the concepts of real property and being able to apply arguments. I know I'm going to do something that's against my thought process always, but it also is serving a purpose. I assigned you one of the most difficult essays in real property. It's the essay I wrote my February 2017 year. We're also going to go over that model answer briefly today, not to like give everyone the answer, but to show everyone how you can write a really strong essay when you're in doubt. I think this is, in my opinion, my favorite essay I've ever seen written, and it'll give you some idea about how to write your essay. And even though I'm showing you the model answer, I still want you to go ahead and write that essay blindly, because it's very instructive. There's also another essay assigned as well. Real property is really tough, and what we're going to do today is something that you all should do on your own and continue. So I'm going to start by sharing my screen. Does anyone have any questions about anything so far? We had a therapy session to start class, but no one really was too interested in speaking. So if we look at the complete drive, we can see that if we look at the complete drive, we can, look at our calendar, always checking in and seeing that this is the last day of property. And then next week, we're going to do a procedure workshop, Civ Pro, Crim Pro, and then a multiple choice workshop. I can't stress how important the next 2 weeks are going to be, because we're going to do Florida multiple choice, which is its own world. But I want to focus this week and, Saturday and Sunday on mastering Florida real property essays. And you should all feel good about these 4 subjects: contracts, torts, con law, and real property as essay subjects. So that's the plan. If we jump into the material, like I said, I wanted to start off by doing these outlines, right? And just looking at them and seeing, okay, these are some of the main points that were tested on previous Florida essays, and this is where they got points. So listen sharply if you may. You'll see this one also tested Article 3 and Article 9, which are no longer primary Florida essay subjects. They'll be multiple choice subjects to be addressed later on in the course. All right, so homestead, call this a con law essay. We could call this a real property essay, but homestead is something that they heavily test. Florida has a homestead exemption. This exists when a homeowner is a resident of Florida and the property in question is either his or his dependent's primary residence. The exemption protects the homestead from forced sale and foreclosure. However, this exemption does not exist for purchase money mortgages on the property or other loans, mortgages, and construction liens used to improve the property, or actions after the failure to pay property taxes on that property. So that's going to be the exception for the homestead is, claims on the house itself or on the property itself, construction liens, mortgages, loans, taxes on the actual property. This exemption affects many of the interests of the loan, and condominium association fees are considered due on the property, therefore not be subject to the homestead exemption. So condominium fees also count as these type of things that, if you owe your condo association tons of money, they can foreclose on your property. PMM, purchase money mortgage. See, we're going to have to know how to write about mortgages, and we're going to be heavily tested on that on the MBE if you're in my MBE course. So property in this particular essay was a purchase money mortgage. And what is that? When the money that is loaned is the money that is actually used to purchase the property for which the loan was obtained. That what a PMM is? PMM is a purchase money mortgage. The facts also specify that this mortgage was recorded, meaning that was properly recorded in the county where the land was located. All subsequent purchasers and security interests had at least constructive notice that the party here had a mortgage on this property. So constructive notice. When I think of constructive notice, I think of notice that's not actual. I believe there is inquiry notice and there is record notice. Inquiry means, if there's someone who's running a farm on the property, you should have looked on the property and seen it. Constructive notice means that it's in the county deeds, the county courthouse records, and you should have, looked up the deed. Actual notice means you literally knew about it. Okay, and then finally, generally when a mortgager transfers his interest to a new buyer before the mortgage is paid off, the buyer takes the property subject to the loan. While the lender may still foreclose on the property, the buyers will not be personally liable and do not need to cover any deficiencies. However, sometimes the buyer will agree with the seller to assume liability for the mortgage. So can anyone explain to me the difference between expressly assuming a mortgage and taking subject to a mortgage?
Wouldn't expressly just be someone telling you that there's a mortgage and you saying, okay, I agree? Like I take the property subject to the mortgage?
Yeah, subject to a mortgage means that you're taking it, but you are not taking on personal liability. You may act as a surety, but you wouldn't be liable personally for any deficiencies or anything like that. Expressly assuming means you are taking over personal liability for the mortgage, and the original mortgager will now become the surety, but you're the one who would be personally liable in the event of any deficiency or anything like that. So they don't really talk about that too much on Florida essays, but you can note on it. And like I always say, the more you can write, the smarter, the better. All right, tenancy by entirety, very important. Let's see. Biscuit in his bow tie, yeah. This guy. All right, tenancy by entirety requires unity in time, title, interest, and possession. Huge. If you write about, JTROS, then you want to write about time, title, interest, and possession. This means the tenants must take an interest in the property at the same time. The land must be granted to the tenants in the same instrument, like the deed. Their interests have to be equal, such that, for example, one party does not have a life estate when the other party has a fee simple, and they must have the same right to possession so that both tenants have a 50-50 interest in the property. In Florida, married couples are presumed to be tenants by the entirety unless otherwise specified. Entirety, it's like a JTROS plus marriage, and we've eliminated the need for a straw man in Florida. So exactly, I just answered the question. A tenancy by entirety is a JTROS plus marriage. So love and marriage. Florida is a lien theory state, which means that when a tenant by the entirety encumbers a property, it does not destroy the tenancy by the entirety. Does everyone know what that means? Understands this? Very likely to be tested. Someone asked me if I was going to predict what kind of stuff was going to be tested on this bar exam. I feel like lien theory, notice jurisdiction, mortgages, it's due. Could I be wrong? Sure. A lien holder only has interest in the tenant's estate. Moreover, when a piece of property is granted to a married couple and the deed says and, both spouses must agree before transferring interest in the property. So, right, there's a lot of things about a lien theory state, but if it's a married couple and we have a JTRS or tenancy by the entirety, you can't transfer the deed without your spouse agreeing. And also because it's a homestead property, maybe that would have implications too. Another thing is that a mortgage on a property will not destroy a JTROS in Florida. And in Florida, if two parties are a JTROS and one of them has a loan, right? And then on the property, and then they die, well, the lender cannot recover from the other party, right? That's what lien theory state means. We'll see that on the essay. So foreclosure action, when a lender must notify all junior interests when it files suit. Generally, the foreclosure of a senior mortgage interest will extinguish not just the interest being foreclosed upon, but all other junior interests. And senior interests are still protected after foreclosure, right? They would have to seek a deficiency judgment to recover. Lender is statute of limitations and lien will attach to the property.
No, not statute of limitations, something more inappropriate, but that's not.
Okay, whatever. I'm not sure, but we'll continue forward, but thank you. All right, let's look at this essay right here. Okay, so this one's about a nuisance, private nuisance. It's like tort, but again, do you see how Florida property can overlap with common law if it's takings or if it's homestead, and then nuisance can overlap with torts because it's constitutional but imposes liability, right? So these subjects are not absolute. A lot of the essays will be like towards common law, family law, let's just say ethics. And I think they're going to do more of that since they removed trust, commercial paper, and secure transactions. I think there'll be more commingled, if you will, essays. All right. What is a nuisance? A private nuisance is any substantial and unreasonable interference with the use and enjoyment of property. The interference must be substantial. An interference is substantial for the community, right? This is all torts. I'm going to kind of skip over this. We know what torts is. Generally, private nuisance is injunction. Now, public nuisance. This is where it brings up constitutional implications. Public nuisance is any activity that interferes with the health or safety of the public at large. And usually, Attorney General is going to bring this suit. I tried to say before that Barbara and her people would do it, but she disclaimed that. Public nuisance has strict standing requirements. In order to collect under public nuisance, a private individual must demonstrate that they have suffered a harm that is different in kind than the general public, a harm different in degrees insufficient. Right, it has to be like a totally different harm, not just in degree. A claim for a public nuisance requires that the defendant's activity constitute a substantial and unreasonable interference with the use and enjoyment of property of the public at large, and at least one homeowner suffers specific injury that is distinct from the common injury suffered by the community. So this is, public nuisance, not so interesting for common law. This is trespass, this is easements, and this is takings. So you see the easements are definitely real property. So this essay, you see it had common law, it had real property, and it had torts. But trespass is like torts and real property, and then easements is totally real property. Easements grant the dominant estate or a party in limited circumstances, right? This would be an easement in gross. The right to use the subservient estate for limited purposes. I don't even think we call it subservient. An implied easement has no writing requirement. An easement by prescription functions similarly to adverse possession of a property, but only for limited use. In order to establish easement by prescription, remember it's ocean, but without the exclusivity, continuous use, statutory period, open and notorious, and hostile. Unlike an adverse possession, there's no requirement that the easement holder have had exclusive use of the property, like we said. The use must have been continuous throughout the statutory period. It must not have been constant, must have been reliable enough for the scope of the easement sought. The use must have lasted the statutory period. They say 7 to 14 years. I don't know if that's right. Easement by prescription in Florida. Does anyone know what the statutory period is?
20 years.
Yeah, is it 20?
Yeah, it's 20.
20, yeah, exactly. Excellent.
And adverse is
7. Yes, right? 21st easement by prescription, 7 for adverse possession. The use must have been such that an observant landowner would be aware of it. In essence, the landowner must have been put on inquiry notice of the use. That's a good way of putting it. The use must have been without the permission of the landowner. Otherwise, there's a freely revocable license. An easement holder has the right to protect their easement from interference, even from the landowner. This includes the dismantling of any barrier erected as an impediment to the easement. So if you have an easement, you have the right to use it. They can't stop you from using it. The overuse of it, you might be liable for a surcharge, and you'd be subject to injunctive damages because you can't overuse an easement. Scarlett, do you mind writing in the chat what you meant by your earlier thing? Because now I'm curious. I won't say it out loud. I just want to know.
Oh, yeah, not a problem.
All right. Takings. Under the Fifth Amendment, the government is permitted to condemn private land for public use so long as it provides the owner with just compensation. Generally, the compensation must be equal to the full market value. The government will be liable for reliance on the assumption that there would be no taking. For example, the government may be required to compensate a party for the cost of recent improvements. However, the government is not responsible for other costs, such as the cost of finding a replacement property. So this is a nice type of essay that I think we could see on an upcoming exam. It has torts elements, it has common law elements, and has real property elements. So if you just know your elements and can state them, well, and do proper IRACs, or as we'll see today, IRAC OAKs, the O stands for opposing argument, then I think you'll do just fine. Okay. Oh, all right. Yeah, I did not think they meant that. One of my students made a joke recently about commandeering clause, and I was so proud of her. I was like, you're so deep in bar prep that you made a funny relative joke about commandeering clause. So this one's about takings. We don't really need to go over that one again. Let's look at this July 2015 one. Oh, she privately messaged me. Okay. So anyway, the acronym SOL doesn't always mean statute of limitations in the internet. It has a different meaning that I just learned. I was today years old when I learned it. All right. When parties enter into a contract to buy property, the doctrine of equitable conversion provides that the buyer is the owner of the property and has a risk of loss as of the signing of the contract, right? Equitable conversion, the risk of loss during the period of escrow will transfer to the buyer. If the buyer received a deed, then all terms of the contract would have merged into the deed, but there was no deed from the seller to buyer. So we have two concepts right off the bat here. We can get points off: equitable conversion and merger. Anyone have any questions about those concepts? Since this was a contract regarding the sale of property, it needs to be in writing, which it was in the statute of frauds. There's a third great point. The equitable owner has the right to assign or devise his interest. When property is conveyed to a husband or wife during their marriage, is presumed to be a tenancy in the entirety. Florida has eliminated the need to have a strong man in order to have a tenancy by the entirety. The description of all that I own is sufficiently descriptive to be a valid will. Florida has accepted this as a sufficient description of property and wills. Florida has adopted the Uniform Simultaneous Death Act, and we'll talk about this when we do wills, which states that if two people die at the same time, it is presumed for purposes of dividing their property that they survived each other. Florida has not adopted the rule that the spouse must survive the other spouse by 120 hours in order to take it out of act. Florida does not allow for exonerations of liens unless it's explicitly stated in the decedent's will. So this is a great example of what everyone's going to ask me. Well, Andrew, they said that secure transactions, commercial paper, and trusts are not going to be tested primarily as essay subjects. What does that mean? It means just like wills is right now. Wills is tested as a multiple choice subject, but every once in a while, there are wills considerations that need to be addressed in an essay. And if you see something, you should address it. So if you see a promissory note, maybe you should speak on how it could be commercial paper, but you will know about commercial paper from studying from multiple choice. But I'm just saying, don't ignore an issue you potentially see because you don't think that that's tested on Florida, right? I think that's a classic mistake people make. They're like, oh, they don't test the elements of crime, so I don't need to write about it. Well, if the question asks, what crimes can they be charged of? You certainly want to write about the elements of the crime. All right, easement appurtenant, there's a serving and dominant estate, it takes two. An easement by necessity arises when one property is divided, and that creates a situation where there's no other way to access a public road. An easement by necessity can terminate if that necessity is no longer there, such as a new road being built, but that's not indicated here. Easement by prescription essentially means an easement by adverse possession. In order for easement to arise, there must have been access that was hostile, adverse, continuous, open, and obvious for the statutory period. In Florida, that period is 20 years. There cannot be an easement by prescription where the servient owner gave consent. What's up, Scarlett? Question?
Yeah, I'm still having trouble. Like, I guess, can you provide me with an example for easement appurtenant? Because I get the easement by necessity, but I really don't. I can't. I'm more of a. I guess I need a hypothetical of like, or an example of how to see that.
Okay. Easement appurtenant is the general type of easement where there's dominant and servient estate. Easement in gross is personal in nature. So comparing easement appurtenant to easement by necessity isn't a really sensible comparison, because an easement by necessity could be an easement appurtenant, right? In fact, it most likely is. Easement appurtenant just means there's two estates. One is burdened by the easement and one is dominating, like kind of like the Nuggets were the dominant estate and the Heat, unfortunately, were the servient estate. That's what an easement appurtenant means. Compare easement appurtenant to easement in gross, which is personal in nature. meaning it doesn't run with the land. It's not tied to the land. It's tied to the utility company or the person who has the easement. So easement appurtenant just means dominant and servant estate. You want an example to remember? Easiest example is two neighbors, and one neighbor has a bridge over his neighbor's property. One neighbor is being burdened by the other estate. That's an easement appurtenant. Thank you. All right, sweet. Okay. Okay. See what we got here. Oh yeah, see, this is another thing. Could be a total landlord-tenant essay. A tenancy by years. Under this type of tenancy, there's a fixed date of termination with no notice required to end the arrangement. End the arrangement. Not the arraignment, that's a criminal term. Barbara got excited there. It expires at a specified time. So tenancy by the years is just like you make a lease for 1 year, you make a lease for 6 months, you make a lease for 2 years. It's just a specified time. Whereas a periodic tenancy repeats itself. A periodic tenancy that continues for a specific period, week to week, month to month, until it's effectively terminated. Termination requires written notice at least 1 month prior in the case of a month-to-month lease, and the lease month end at a natural lease period. I have the exact dates of these written down on one of my outlines. So, that's something I would study like the week before the test, but just know the terminology for now. Right now, always focus while we're still over a month away, while we're still over 2 to 3 weeks away, focus on concepts and terminology, not so much on dates. Dates is like the sheer focus of the last week when you're just like 7 days, 14 days, 21 days, Right now, I just want it to be more conceptualized. So we have tenancy by years, tenancy, periodic tenancy, and periodic tenancy is a lease agreement in which the tenancy is for periods of time as determined by the cycle of payments. A periodic tenancy can be created expressly or by written agreement or by implication. Moreover, a periodic tenancy can be terminated by providing the landlord with notice of intent to terminate the lease in which the no period in advance. That's typically the rule, 1 period in advance. Something to note is if tenancy by years fails, let's say there was no lease, it was oral and it needs to conform with the statute of frauds because it was a 2-year lease, then what will arise is an implied periodic tenancy. Does anyone question that or understand that? Fail to understand that? If a intended tenancy for years fails, let's say because it doesn't conform with the statute of frauds, the result will most likely be a periodic tenancy, and you'll have those termination conditions. So to terminate a month-to-month, valid notice of at least 1 month is required in writing. The lease must also end at a natural lease period. Surrender occurs when a tenant abandons his tenancy and the landlord takes possession and control of the premises. If this isn't correct right here, it might be because it's an old essay. Like I said, I'm not exactly sure right now, and we'll confirm that before the end of the test. I'm just going for the concepts. Surrender occurs when a tenant abandons a tenancy and the landlord takes possession and control of the premises. That's surrender. So the tenant abandons a tenancy and the landlord takes possession and control. However, a landlord may move in and attempt to relet the premises on behalf of the tenant, which will not result in a surrender. A tenant has a duty to pay rent. Where a tenant fails to pay rent and abandons the premises, a landlord may treat the abandonment as a subrent and relet and sue for damages, and may, in some minority jurisdictions, can ignore the abandonment and sue for damages without attempting to relet the apartment. So know that in Florida, you do have to attempt to relet. It's like mitigation in a contract. If they surrender, you still have to try to relet it and then sue for the difference instead of just suing for the remainder. Constructive eviction occurs when there's a condition on the premises that makes it uninhabitable. The landlord knows or should have known about the condition. The landlord fails to remedy the condition, and the tenant moves out within a reasonable time. So that's a constructive eviction, right? It's so gross that I had to leave. It's so, the rain is just pouring in. Implied warranty of habitability. The doctrine only applies to residential leases. Under this doctrine, a landlord warrants that the premises are suitable for human habitation. Usually the covenants between the landlord and tenant are independent, making the breach by one giving rise simply to damages and not a right to terminate. The implied warranty of quiet enjoyment is an implied warranty that the landlord will not interfere unreasonably with the tenant's use and possession of the premises. This warranty can be breached by an actual and a constructive eviction. To make a claim for constructive eviction, and for this warranty to be breached, There must be substantial interference caused by the landlord, over which the landlord had notice but failed to act. The tenant must provide notice of the interference and problems, and then the tenant must move out immediately. Where this warranty is breached and a constructive eviction has occurred, the tenant may leave immediately, and terminate all future payments of rent. A landlord has a duty to mitigate damages by six. Damages for failure to pay rent will be awarded when the damages are foreseeable, casual, unavoidable, and certain. Unavoidable requires the non-breaching party to take reasonable steps to mitigate any losses he may have suffered. When a person has abandoned the premises and fails to pay rent, the landlord must attempt to relet the apartment. Then it will be appropriate for the landlord to sue for the difference between the initial lease payments and the payments made by the reletter, as well as any incidental damages. So this was literally an essay totally about a landlord-tenant. Do you see what I said earlier about how there's no prompt I can really give you or structure for writing a real property essay? It could totally be about a mortgage. It could totally be about landlord-tenant. It could be about takings or who knows? It could really be about anything, adverse possession, covenants, deeds, all sorts of things. So real property, I say, is very tough because it's all about vocab. You got to know the warranties. You know, we didn't even talk about the deed and the 6 covenants of a general warranty deed, covenant of size and right to convey, right against encumbrances, present warranties, future warranties, right of quiet enjoyment, further assurances, and general warranties, right? These things that I have literally off the top of my head are what you all need to have off the top of your head to be able to do well on a real property essay. It really is a process of knowing terminology, identifying it, making strong arguments and counter arguments, and moving forward. And flashcards could be very helpful for those. Yeah, Lexi said month to month is 15 days. That's what I thought. Month to month is 15 days for residential. That's why these model answers, like these outlines are created from the model answers. They are not perfect, but the Florida bar doesn't do us the care of editing them. That's why I try to edit them as I go along. Let's look at one more and then we'll get to doing some essays by ourselves. It'll be super fun. Okay. A lease or leasehold estate is an interest in land whereby the landholder grants another person, the tenant, the exclusive use of the land for a limited period of time, subject to certain terms and conditions, if any set forth in the lease, right? A leasehold versus a freehold estate. A freehold estate is like a fee simple. A leasehold estate is like, you know, a lease. Waste is an action initiated by a person with an interest in the land, usually a holder in fee or remainder man, against the occupier of the land for harm to the land caused by the occupier's actions. Typically, an action for waste lies when the occupier's action is physically damaging the land, such as where the occupier removes trees or minerals for commercial use. Ejectment, which is when we do civil procedure, action that was available at common law in 1776, just foreshadowing that wretched world of Cipro. Ejectment is an action at law whereby one claiming a superior interest in a parcel of land seeks to have the present occupier removed. Absent any provision in the lease to the contrary, a lease is freely alienable, meaning that it may be assigned and subletted. A sublease is an interest in land created when a tenant transfers part of his leasehold interest to another party. Remember, sublease is like the middle, assignment is the remainder to the end. Not the remainder man, but like just your lease until it ends. That's a really difficult thing about the bar exam is a lot of terminology will conflict with each other. Like we already heard merger. Merger can mean a contract merging into a deed. Merger can also mean the process of implied easement being terminated when 2 parcels of land are merged, right? So you hear words and you're like, wait, I thought it meant this. Here it means that. Similarly, right? So yeah, that's a concept that we're talking about. I was talking about assignment, right? A sublease versus assignment. Assignment is going to be to the remainder, and I meant the remainder being the remainder of the term, not necessarily a remainder man who is pretty sexually inconsiderate way of talking about someone who follows. I mean, it could be a remainder woman. That's all I meant. I don't know why we have to say remainder man. The remainder person. All right. An estate can never last longer than the estate in which it depends, which is why an assignment or sublease can never be for a longer period of time than the sublessor has remaining its term. That makes perfect sense. Under the doctrine of fixtures or mergers, when an occupier of land affixes any object to the land or to any structure built on the land, those items merge into the land. Here, another reason of merger. The general rule is that an occupier is not entitled to remove fixtures from the occupied property when the state terminates. All right, just did this question on the MBE. You have a house, there's a garbage disposal, there's a lawnmower, and there's a ceiling fan. Which of them are fixtures?
Ceiling fan and garbage disposal.
Exactly, because if you shake the house, the ceiling fan is affixed to the house, it's still staying on. The garbage disposal should be obvious. Now, here's another example. I buy a property, it's a warehouse, and I turn it into a boxing gym, my dream. And I put all these punching bags in the wall, but I screw them into the wall, into not the wall, into the floor. I screw them into the floor, right? Can I remove them when I leave?
Yes.
So long as
You fix it.
right, I don't damage the property. Exactly. Those would be called
Trade fixtures.
Multiple fixtures.
trade fixtures or commercial fixtures. Both answers will be accepted. Rosie's going, she senses something. Okay. Under the doctrine of fixtures and mergers, when an occupier of land affixes to a thing, it merges. Excellent. Zoning ordinances are laws restricting the use of land and are a valid exercise of police power inherent in the states and their political subdivisions. All right, I want to talk a little bit about zoning thing right here because I got some interesting points. First off, does anyone know what a variance is?
Doing something different.
Applying to do something different than you're zoned for. Does anyone know what a non-conforming use is?
When your grandfather in.
Right, when you're grandfathered into doing something different, you were doing something that didn't conform before the zoning laws changed, and now you're allowed to continue doing it. How about an amortization?
When you slowly stop doing that.
And you usually get compensated by the government for doing that. Excellent. All right. Can anyone explain to me cumulative use? Cumulative zoning?
That's using like multiple where it's like residential and like commercial, right?
Right. So if you're if under cumulative zoning, if you're zoned for commercial, what are you also zoned for?
Residential.
Exactly. Anything below it. Right. If you're cumulatively zoned for commercial, are you zoned for industrial? No, because that's above you, right? Residential. Exactly. Awesome. All right. A local government has the authority to pass zoning ordinances under general police power to legislate for the well-being of all citizens. This power, however, cannot be employed in a way that violates a citizen's right to due process or equal protection, or that amounts to an unauthorized taking of private property. See, dropping some con law on you in this beautiful Saturday morning. Denial of permit will be deemed unlawful unless it was arbitrary or capricious in violation of the 14th Amendment to the United States Constitution. An unlawful taking of a property for public use without just compensation in violation of the 5th or 14th Amendments to the United States Constitution, or otherwise illegal, unlawfully discriminatory, or otherwise violative of state law, federal law. So look, there wasn't so much from this essay. It was just, you know, some key points. Ejectment, right? And that's an action where you're kicking someone out. Does anyone know what it's called if you have a landlord and then you switch to a new landlord? Pop quiz, hot shots. That's a game me and my brother used to play. My brother, soon to be father of two. No one knows what that's called? Oh, the chat room is booming. Starts with an A. There we go. Nice, we're playing that game. I'm Vanna White. Yes. Hey, a tournament. Good job, Isadora. Good job. Is she still doing that, Vanna White, or is that like no chance? Doesn't even know who that is. Okay. Any questions, concerns about anything so far before we look at it? Are you serious, Barbara? Is that serious? Oh, rest in peace, Vanna White. Let's just take a moment. All right, let's do some real property essays. Any questions?
I'm just sorry, it's not a funny
that's a
joke.
joke?
It's not a joke. I mean, it's a bad joke. It's not funny.
Is it true or not?
No, it's not. It's not true.
Isn't she? Oh, What? Can you all just give me 1 second? Yeah, she's 66 years old. She looks great. All right, Vanna, well, sorry to stranger you. Sorry. Does she still do Jeopardy is the question I was asking, not if she still walk this earth. Yes, she does still do, not Jeopardy, Wheel of Fortune. All right, cool. Cool. There she is. See? She's literally 1 year younger, 1 year older than my dad. Okay, let us talk about property and essays. Any questions at all about anything so far, about any of the subjects we went over, or anything in particular before we do issue spotting together as a class?
I have a quick question about life state. When the grantor grants a life state to a person, and then, for example, for Nancy, to Nancy for life, and then to A and B. The A and B there is the remainder. If Nancy wants to do
Your
convert
question
the
is so specific from February
Yeah.
2017. But
yeah.
okay.
Yes, because it was a very hard essay, and it keeps coming back to me. If Nancy she wants to convert the house into 2 offices, and she needs permission from the remainder, or no?
Yes, because that's ameliorative waste, right?
Mhm.
Not to give away this essay, but yes, she had a life estate and she was a lawyer, and lawyers think they can do whatever they want, however they want, whenever they want. So she built these office buildings on the estate and said, hey, look, I improved the value of the property. And the remainder men said, hold your horses, Nancy. You don't have the right to do that. We are the ones entitled to this property, and we don't want your office buildings on it. We're going to turn it into a farm, an exotic tree farm. So yes, they do have rights against the life estate holder. Cumulative zoning, you're saying, Barbara. You said applies to commercial and residential, but not which classification. I was just giving a hypothetical, industrial. In my hypothetical universe, there's 3 zones: industrial, commercial, residential, in that order. So I was just giving an example. If you're zoned for industrial under cumulative zoning, then you would have all 3. If you're zoned for residential under cumulative zoning, you would only have residential. If it's not cumulative zoning, you're just zoned for what you're zoned for. It'll tell you in the fact pattern. Again, probably MBE, but you know, it never hurts. The more you know, the better things will be in life. Any other questions about anything at all? It's like perfect time to transition. Nothing? Gabby, you almost look like you have a question.
Sorry, my cousin is getting married today, and my mom and sister, I can hear them yelling about logistics like right outside the door. And so I was yelling at them that I'm here. So I need to keep it down.
My cousin's also getting married today. I can't go to the wedding. My heart is broken, but I'm gonna send her a nice gift. My parents will be there for me. She's like my second cousin, and she's getting married in New York. And you know, I'm committed to my work, so here we are. But it's a great day to get married, so love is in the air. That's what's up. Let's look at essays, real property, and oh, I'm sorry. You know, this is not the 4 that I wanted to bring in here. That's why I was confused. Any questions about anything at all? Florida study materials, Florida essay subjects. I'll make sure I upload this, but then official essays and model answers. That's where I want to go.
Can I
Real property.
request
So I need
an
to,
essay?
yeah, go ahead.
The July 2020, what year is this year? So 2022.
July 2022. Yeah.
Yeah. That one was really good about like mixing a bunch of subjects in it. It was more like contracts and property, but
So I saw this post by someone, and he's a DJ, and DJs allegedly hate when people request songs. Like that's their biggest pet peeve. And then they create this technology where it's like an app where if you want a song, you can request it, and then you commit to spending a certain amount of money. And then if the DJ, if it's enough, we can accept the money and then play the song. So that was pretty cool. So can you send me $2 to my Cash App right now for this essay? And I'll do it. No, which one did you say? July 2022?
yeah.
All right. But I think that's pretty cool. I like modern solutions to modern problems. Pay the DJ if you want to play Old Town Road for the 6th time. Okay. Here we go. Well, it has contracts involved too, which is fair because we like contracts, right? I already know what this is going to be about. If it's contracts and real property, it's going to have to be about the representations that were made, probably, right? Like, what's that? Yeah. All right, cool. Let's do this. Oh, wow, this is wrong. Prepare a memorandum, my favorite, that addresses the claims, defenses, and possible remedies in a lawsuit by Natalia and Mitchell against the sellers, whether Natalia and Mitchell have any legal obligation to pay the early termination fee to the alarm company and any ethical considerations. So just because you wanted this, you asked for it. I know I'm probably doing this a slower way than most people would. Going over people die. I saw another post that said, like, you're not a 90s kid, you're in your 30s and you're old. Right, that's life. Okay, so let's see what we got here. I was born in the 80s too. The best era. Prepare a memo that addresses the claims, defenses, and possible remedies in a lawsuit by Natalia and Mitchell against the sellers. So that's the first thing. Whether Natalia and Mitchell have any legal obligations to pay the early termination fee to the alarm company and any ethical considerations, which we probably won't really discuss. So, you know, I would say this memo would discuss these things, and then boom, we're looking for claims, defenses, and remedies, and we're looking for NVM, right? So does anyone mind reading the first, let's say, 2 paragraphs and leading, you know, then we'll go into issue spotting? Anyone mind reading them?
I can read it.
Awesome, go ahead.
Okay, Natalia and Mitchell decided to buy their first home. They found their dream home and noticed that it was located in a flood zone. The sellers provided Natalia and Mitchell with a disclosure form which included the question, has flooding affected the property? In response, the sellers answered no. Natalia and Mitchell offered to purchase the home for $300,000. The sellers accepted the offer. Natalia and Mitchell hired an inspector who came out to the premises and reported that the home appeared to be in good condition and the sale closed shortly after.
All right, what issues can we spot? And just issues. The goal here is to just get points. I don't care conclusions, issues.
Habitability.
I'm sorry. Wait, Scarlett, actually let her continue. What were you saying?
Oh, warranty of habitability.
Okay, warranty of habitability. What else?
There's obviously going to be a land sale contract, so like price, etc.
Johnson for Davies, no?
Yeah, I like all these things. So we said warranty of habitability. What was the second thing you said? Duty to disclose?
Land. Oh, I didn't say that, but yeah, put it. Someone else said it. And then land sale contract.
Which is going to implicate the statute of frauds.
Yeah, and making sure it has
You
everything.
said to disclose, which is going to implicate Johnson v. Davis.
I'd write in for now something with notice, just because like they inspected and probably something's going to come up with inquiry notice.
Notice, inspection. So cool. All right. Let's see what the chat. Concealment. Okay, potentially. I mean, we don't know if they're concealing yet, but it seems concealing. There's
Misrepresentation.
Concealment, misrepresentation. That's contractual. I like that. What's up, Scarlett? You have your hand up. Anything you want to add?
Yeah, like probably like they didn't properly like disclaim that warranty, because if they wanted to disclaim that there was no flooding, they would have had to put that in they would have had to say like, oh, I'm not gonna warrant that there is no flooding in this area. So I would probably talk about that a little bit.
Yeah, someone already mentioned warranty of habitability, and you're saying the disclaimer. I like that. Just any vocab words anyone can mention, we like. So it was an express warranty, right? Like they express warranty because they said no, literally. First home, their first home. I kind of like that. So
Homestead.
Yeah, buyers. Someone said homestead potentially.
Yeah,
Right.
maybe.
Right, like who knows? We might not write about this, but I don't mind what we're doing here. We're just thinking about things. They offered to purchase it, so offer, acceptance, consideration. So we have a contract, right? Like we don't know this is all property. It could be contract law. So offer, acceptance, consideration, is it under UCC or
Uh,
common?
Common law, but I would also add in risk of loss buyer because they signed already.
I like that. Risk of loss passes to buyer. What do you call that?
Equitable conversion.
Do you see what we're doing here? This is how you approach 2 paragraphs. Like, you can't tell me 1 sentence without me thinking of 3 potential issues. Tom walked to the park. Oh, what's his duty of care? That of an average walker to the park. You know what I mean? Like, you just got to start thinking about life like that. Like, for better or for worse, I want you to, for better. You'll never be as smart as you are a month from now. I swear to you, this is when you know the most and when you're the most dangerous to society because you're equipped with knowledge. And this is so many issues that we see. Habitability, land sale contract, statute of frauds, due disclose, Johnson v. Davis, right? Can someone define Johnson v. Davis, what that tells us?
You have a duty to disclose latent defects.
Yes. Notice potentially, and Florida is a what type of notice jurisdiction are we?
Sure.
Pure notice. Pure as the driven snow. Concealment, misrepresentation, disclaimer of warranties, express warranty, inexperienced buyers, homestead exemption, offer acceptance consideration, common law, risk of loss passes to the buyer. Nice. Anything else? It is appeared to be in good condition. Sale closed shortly thereafter. $300,000. Was there a deed ever? I don't know if there was or wasn't, but just maybe deed formalities. Title. Like, these are just thoughts. I'm probably not going to get these into my essay, but some people say, Andrew, I wrote my essay in 45 minutes. What do I do? Write about the, add stuff. That's the answer. Okay, Natalia. Oh, would someone else mind reading the next paragraph? I'm kind of leading the discussion.
I got it. Which one, Natalia?
Yeah.
Okay. Natalia asked an alarm company to install an alarm in the home the day after they moved in. The alarm company technician arrived and presented her with a 5-year contract with the following early termination penalty provision. If you terminate your contract before the expiration of its 5-year term, an early termination fee of 80% of your total remaining balance on the 5-year contract will be due immediately. Keep going. Natalia asked an alarm company to, okay, that's good. Natalia was not sure if she would like the alarm company service and did not want to be penalized for an early termination. She crossed out an early termination penalty provision and any reference to a 5-year term and then signed the contract. The technician took the signed contract back, placed it in a folder in his vehicle, and installed the alarm system.
So, to be fair, this seems like contracts, right? This seems like contracts. Today's a real property essay. Day. This is all contracts, right? And what specifically type of contract is this, and what does it implicate?
This will be a service contract, will be liquidated damages, and it'll also be crossing out and signing and waiver of the provision because he performed.
Right, so much stuff here, right? It's going to be, is this a mirror image? Is this an acceptance? Is there a promise, some sort of exception? All this stuff. But to be fair, everyone, I didn't want to talk about contracts in too much detail today. Let's continue. How about Lexi, since you're the DJ requester, why don't you read the next 2 paragraphs?
Sure. 5 days after Natalia and Mitchell moved into the home, they awakened to their furniture soaking in a foot of water inside the home. They looked outside their living room window and saw that their 2 cars in the driveway were flooded with water. 2 of Natalia and Mitchell's new neighbors came by the home that morning. The neighbors explained that the flooding was a regular problem on their street. The neighbors said that the sellers who sold the home to Natalia and Mitchell frequently complained about the flooding problem and were often seen walking through floodwater in the home's front yard with their pants rolled up.
Awesome. So what is implicated here? Lexi?
I would,
Oh, sorry, I'm picking on Lexi right now. You don't mind?
I think it's about how the previous sellers did have notice of the flooding problem.
What
That's the
type of
big
notice?
deal.
At least they had what type of notice? At least.
That there was known defects.
I would say at least.
Oh,
someone that-
okay.
privately. At least, yeah, Barbara's saying constructive notice, at least constructive, if not actual. Everyone's saying actual, yeah, I'm saying probably actual, but at the very least, inquiry notice, right? The neighbors said that, the neighbors complained about it, like if you just looked at the property, you would have known that there was flooding. They had definitely had some notice. I think this is all of our anxieties came true, right? We thought that this would be a concealment, a failure to disclose, a misrepresentation, a notice, fraudulent misrepresentation, all these issues that we thought were going to come up were going to come up. Now you need to be careful on how to address these issues. It's about doing the IRACs. The issue is whether they had noticed. The rule is actual constructive inquiry. Here they would have had inquiry there. They would have had, you need to go through it all. So yeah, it's a pretty bad place. There's just a question that I want to ask the group. Do you think we talk about deeds here?
Yes.
could be maybe a general warranty deed.
Yeah, that's my piece. Could be maybe a general warranty deed, could be maybe, that's when you would have quiet enjoyment. If they said, like, right, that, I don't know. I don't know what the model answer says. They might not address this at all. I'm just saying what I would do. If I was similarly situated under the duty of care, I would probably at least mention if they had received the general warranty deed, they would have received these 6 covenants. The future covenant of quiet enjoyment is obviously implicated here because, there's water in their home and that's something you could sue under. So do you talk about deeds? Do you talk about deed formality? Do you talk about general warranty deeds? I don't know that you have to, but I would, when in doubt, write it out. I have so many sayings. That's the one saying I like. When in doubt, write it out. Like I would, but again, maybe it's not the most important thing. The most important thing is certainly the concealment, misrep, fraud. I like the duty to disclose, all those types of issues. Let's see. My chat box. Depending on the type of deed, determine what the remedies are. So some people are saying you don't talk about the deed, some people are saying you are. I probably would. I don't know if the model answer is going to, but I think it's just more potential points. And my thought process is if I write about this, I'm not going to lose points. But if I don't write about it, I could potentially not gain points. So, when we do the issue spotting like we did, it'd probably be down here, general warranty deed, and then 6 warranties, especially I'm thinking of quiet enjoyment. I mean, I do think you would write about quiet enjoyment here. I do think, like, even if you didn't mention the deed, it seems relevant. Regardless, I wouldn't start with it. I would start with these different types of things. Now, someone says warranty of habitability. Warranty of habitability is a landlord-tenant duty, right? Quiet enjoyment is a land sale duty. So maybe it isn't habitability. Maybe it is quiet enjoyment. Either way, you don't get points off for identifying potential issues. And that's the process I'm trying to teach is get better at issue spotting. And then you have more tools in your toolbox to create a nicely written essay. I was working with a student in one of her essays. It was her best essay. I noticed she wrote a great ethics piece. And I was like, wow, how'd you do that? And she's like, oh, I wrote about ethics first, even though it was at the end of her essay. I was like, oh, that's smart. That's playing chess, right? I love chess. There's a lot of chess on this test. Do things, position yourself for the end game. Okay, so why don't we take a look? Let's see what else happens. They were furious. She moved in with the parents. Okay, so is it a lease or it's a sale, right? It's the purchase of the home. So it's not going to be habitability. It would be quiet enjoyment, I would think. And then the termination fee, that's a contract issue. They sought advice from the lawyer advertising, you can't advertise like things that aren't true. You can't say we get 100% success rate. You've only had one client, right? Things like that. Mandatory arbitration, whatever. We're not going to go into the legal fees today. We'll do that in a couple weeks. But now prepare a memo that addresses these different things and watch how they weave in together a lot of these issues that we spotted. Is any thoughts, Lexi? Because this was your request. Anything else you want us to talk about that confused you?
No, that's good. I think I just really missed a lot of things. And now throughout this whole course, I've been learning how to pull everything out. So it's been good. It's good.
Yeah, and I think if I recall, you had a pretty high score the last time, and it's not like you need a super, super high improvement. You just need to tighten up. And I think my course does do that. It shows you how you can get more points. And sure, you probably wrote a good essay, but we're trying to write these great, grand, wonderful essays. So I'm glad that you appreciate that. And if you listen to my offer, maybe you can do a whole hour session with me. All right, so look at this memo. Do you disclose under Florida law, a seller has a duty to disclose no material defects in property that are not easily discovered by a buyer. Huge piece right there. These latent defects must be those that are significant and that would make a buyer reconsider had she known of the defect. This is the Johnson v. Davis claim. A defect that is observable or one when the buyer knew or should have known fall outside this duty. Here the facts indicate that the buyer's home was flooded soon after moving into. Seller did not disclose whether there was a history of flooding at the time of the contract. However, the facts also indicate that the buyers noticed the property was in a flood zone. Seller would argue that they were on notice that the property could be flooded given its location in the flood zone, and therefore no duty existed. However, buyers would argue that a property being in a flood zone versus having a history of flooding are two separate issues. Neighbors allege that the sellers knew of the flooding problem as they frequently complained. Because there was a history of flooding as material, sellers were under duty to disclose. You see how they do the opposing argument? I think one thing that not everyone, but a lot of people miss out on is you have to do opposing argument, even if it's so clear that A is right. And I think, I keep mentioning Barbara because she's a practicing attorney. She does criminal law. And sometimes you have to make arguments that might not have the best chances of winning, but you still need to present them. And that's a skill that we want to work on. All right, active concealment. In Florida, a seller is prohibited. This person needs to work on it. Sorry. A Florida seller is prohibited from actively concealing defects in a property, right? Concealment, good job, right? A seller cannot take steps to conceal the discovery of known material defects. Here, the sellers provide a disclosure which stated that the property did not have a history of flooding. This information was false, as the neighbors state that the sellers often complained about the flooding in the property. The flooding issue is a material defect. The sellers would argue that the flooding was not concealed as it was located in the flood zone, and the buyers could have asked the neighbors for information if they sought to inquire. However, because the buyers did inquire to the sellers and the seller affirmatively replied no, the buyers have a claim for active concealment. Any questions about active concealment? Hey, Zalpa, are you with us today?
Yep, I'm right here.
Nice. I got a message from Amy checking in on you.
Yeah,
That's the thing about us. We care. Almost
I
too
know.
much. All right, but good job. You're actively participating, not concealing. Okay. Intentional misrepresentation. Intentional misrep occurs when one party intentionally misrepresents facts to another party. Here, sellers stated that the property did not have a history of flooding. This disclosure was false given the evidence mentioned above. We can presume it was intentional since the buyer stated that the sellers often complained of the issue. Therefore, buyers have a cause of action against the sellers for intentional misrepresentation. You see, they're throwing the kitchen sink of claims. Negligent misrepresentation. Negligent misrepresentation exists when a party has a duty, usually in professional capacity, is negligent in disclosing or not disclosing facts. The inspector informed the buyers that it was in good condition. The buyers relied on that representation. He had a duty to conduct due diligence. Therefore, the buyers have a claim for negligent misrep, right? When there's an IIDD, there's an NIED. When there's an intentional misrep, there's a negligent misrep. It's just, if you're a good attorney and you're trying to win a case, you're going to say, A, we have a strong claim for breach of contract. In the alternative, this is our other claim. You want to do that. You want to, okay, the judge might strike out 7 of your arguments, but as long as one of them hits, that's what we're trying to do here. So equitable remedies in the deed, see, they went into deeds, they went into warranty deeds. I told you, I didn't tell you, but I predicted that it was a potential. They didn't go into it too much, but they did mention it. The buyer's legal remedy, oh, see, they did go into all 6 of them. The buyer's legal remedy or equitable remedies will depend on the type of deed provided. That's literally what Barbara said. Excellent job. Because any promise contained in the sales merge with the deed, concept of merger. There are 2 types of deeds, quitclaim deeds and warranty deeds. A quitclaim deeds makes no, there are actually 3 types of deeds. What type of deed are we missing here?
Special.
Special warranty. Yeah, see, we're trying to reach for the stars a little bit further. A quitclaim deed makes no guarantees as to quality of title or on the property. While warranty deed contains 6 covenants which are sizen, right to convey, warranty against encumbrances, breach at time of closing, further insurances, quiet enjoyment of warranty, breach after closing, further assurances. We would need to know what type of deed to see whether there's a remedy at law or equity right. See, it was important, like, it wasn't important, but they probably got points for it. And then the early termination fee, this is contract invalid, offer acceptance consideration, bargain for exchange, statute of frauds, liquidated damages, and then ethics. But all the property things were what we mentioned, like nothing more than we mentioned. We crushed it as a class. See, Homestead didn't come up. Okay. Inexperienced buyers, they didn't mention. I would have got a point for that. Risk of loss, equitable conversion. Yeah, we're getting that point. Like, if they got a point for the deeds, then why wouldn't we get a point for risk of loss? If they got a point for mentioning the 6 type of deeds, why couldn't I get a point for assuming that this complied with deed formalities? I'm just saying, I have gotten really high scores on my essays, and that's how I write essays. So there's a strong likelihood that it's actually a good approach. And my students who have taken that approach have done really well. I'm going to show you one of my favorite essays of all time right now. And I'm not going to go into it too detailed because I don't want to give away all the sauce because I actually assigned it. But I want to go into the structure of it because I think it's so beautifully written. No, I don't think it's so beautifully written. I just like it. I just think it's helpful. It's not that beautifully written. I like poetry. What was the poem? Oh, I actually quoted a poem at the beginning of class. I don't think everyone missed it. I said, we have promises to keep and miles to go before we sleep. Anyone know what that's from? Man, education system is failing. Okay. So, anywho, let's talk about this essay that I assigned. At the beginning of class, Ariane was talking about a random woman named Nancy who had she was clearly alluding to this essay. I'm gonna just read this essay aloud so everyone, sit back, relax, grab some popcorn and listen to the essay, and then we'll go over how it's answered. But I still want you to try and write this essay yourselves because it's that hard. All right. Prepare a memo that discusses each party's interest in the property, the likely outcomes for the competing claims to the property and the claims for eviction, reimbursement, and partition. Also discuss any ethical issues arising for the attorney's conduct. One thing I want everyone to know is they mention the word tax deed and they don't even address it in the essay, meaning I wrote on my essay, tax deeds are valid and enforceable in Florida and move forward. They didn't even do that and they still got the model essay. So, if you just get tricked by one word, it's okay. Okay. A woman owns property and she gives the property to her 2 adult sons, Scott and Doug. The deeds state that the brothers take the property with the right of survivorship. This is not a homestead property. Without Scott's knowledge or consent, Doug gets a loan from Tom and pledges the property as collateral. Doug fails to make several payments and dies before the loan is paid off. Tom says he'll foreclose if Scott doesn't repay the loan, but Scott refuses. For $10 in consideration, Scott deeds the property to his niece, Nancy, for life, and then to Tom and a local charity in equal shares. So just to slow down a little bit, woman owns the property. She gives it to her 2 adult sons. Here, deed formalities, what kind of deed was it? The deed states that the right of survivorship. So we're going to go into JTROS and what that all means. Not a homestead property. I'd probably say why that's important. Without Scott's knowledge or consent, he gets a loan from Tom and pledges it collateral. What does this implicate? Does anyone know?
Like severe
Name here.
joint tenancy.
It won't sever the joint tenancy with right of survivorship.
Right.
How do you know that?
Because Florida's a lien territory,
Because
state.
Florida's a lien theory state. If you didn't know that Florida's a lien theory state and you didn't see that, you're probably not passing this essay. That's crucial that this is a lien theory essay. So because he gets a loan with it, whatever, it doesn't matter. It doesn't serve the JTRS. Doug fails to make several payments and dies. Why is that important? Who cares about the death of Doug? Doug Funny.
Scott. Sorry,
On the
Tom.
joint tenancy, like that, it doesn't go to his heirs, his portion of the
So
The
Tom
tenancy.
says he'll foreclose if Scott doesn't repay the loan, but Scott refuses. Does Scott have to repay the loan? And can Tom foreclose?
No, because his interest is extinguished once Doug dies.
Exactly. That's
Therefore,
what,
he owns it in whole.
exactly. You can't, if the party dies, you're not going to be able to recover from the other party under lien theory jurisdiction. Very important stuff. Okay. For $10 in consideration, Scott deeds the property to his niece, Nancy, for life, and then to Tom and a local charity in equal shares. The property has a small house, and Nancy spends $25,000 to convert into 2 offices. Ariane asked about this. That's clearly what type of waste?
Ameliorative.
Ameliorative waste, right? Nancy orally agrees to rent these offices to Tom and to an attorney for 5 years, with rent to be paid quarterly. What does this implicate?
Tenancy for
Issa's saying
years.
statute of frauds, right? Orally agrees. Why is a 5-year term orally? What's the problem there?
It's not in writing.
Yeah, it's not in writing. So what did I say earlier? What did I allude to? That if a tenancy for years does not conform to the statute of frauds, what does it most likely mean?
Periodic tenancy.
Periodic.
It's most likely a periodic tenancy. And Scarlett, who clearly has similar attention issues as me, is giving us an ethics thing right now. I love that, Scarlett. That's amazing. We'll use that, but let's focus on real property right now. And I'm not trying to make funny. I have the same attention issues, not issues, attention, attention. Okay, so Nancy already agrees to rent these offices to Tom and to an attorney for 5-year terms. We said that this has to comply with the statute of frauds because it's over 1 year, and that since it's not a tenancy for years because it fails with the statute of frauds, it'll most likely end up being a periodic tenancy, right? Okay, yeah, multitaskers. There you go, Barbara. Multitaskers. That's the word I was looking for. So the attorney deposits Tom's quarterly rent payments from the operating account. So here we go. What Scarlett just sent us. That's definitely a violation. But the key things here is ameliorative waste, right? Statute of frauds because it's oral, and then what type of tenancy is probably a periodic tenancy. What about this? He deeds the property to his niece Nancy for life, and then to Tom and local charity in equal shares. What do Tom and local charity have? Remainders. Exactly. And what about this $10 in consideration? What's up with that? What's up with that?
It's for the deed. Like, if there's a valid.
Yeah, it's probably sham consideration, like Scarlett's saying. Like, who cares? Once the deed's recorded, we don't need consideration. Contract merges with the deed. Excellent. Everyone have this? And hey, Scarlett, or anyone, if you have materials or whatever, please put them in the Telegram chat too, because some people, don't come to class, don't get the chat. I'm all about sharing helpful material with each other, especially if you create it yourself. Okay, so we have some key thoughts here. We're going to have to talk about JTROS. We're going to have to talk about deed formalities. We're going to have to talk about types of deeds. We're going to have to talk about lien theory state. We're going to have to talk about ameliorative waste. We're going to have to talk about statute of frauds. We're going to have to talk about periodic tenancy versus tenancy for years. And we're probably going to talk about sham consideration and remainder men and life estates. Any other questions? The attorney forgets to pay the taxes due in the first year. Nancy does not pay the taxes either. Instead, she waits and buys a tax certificate for the amount of unpaid taxes. 2 years later, she applies for and receives a tax deed. Right? This is what everyone gets so confused about. When I saw this on my essay, I thought I was going to fail the exam. I was like, I had studied the wrong materials. What am I supposed to do here? Look that way. So they might hit you with some super surprising thing on test day. Don't freak out, just keep moving. You don't need to get a perfect score, you just need to get a good score. So here, a tax deed means if you have outstanding taxes on the property, you can apply for a tax deed, and if you pay it off, then you basically shown that you paid the taxes off on the property. And either the person who owes those taxes has to pay you, or if you were the one who owed the taxes, then you could show the county that you no longer owe the taxes because you received a tax deed. So it just says Nancy has received a tax deed. That's fine. Why is it important that Nancy has received a tax deed? Because she's a life estate tenant. And why is that important?
For like the duties of what they have to pay.
The duties. And what are the duties of the life estate tenant?
To pay taxes on interest if they're living in the property or leasing the property.
Right. Taxes and interest if they're making use or renting the property out. Right. Excellent. Really good stuff. There's so much to talk about in this essay. And remember the common law essay that I assigned to everyone, that was about the newspaper and the mayor and the defamation and the sheriff. That was the same year, back to back. I wrote both those essays. So like it can be 3 really, really difficult essays. Or in my opinion, the February 2023 essays were kind of 3 cupcake essays. They are all over the place with the difficulty of it. So you just have to prepare for war, you know, prepare for the toughest battle, and then we'll be prepared for anything. Okay, so she wants to claim she owns a property based on the tax deed. Own the property outright based on the tax deed? If you pay off a tax deed as a life estate tenant, do you own the property outright?
No.
No,
The
absolutely
remainder.
not. That's ridiculous, right? The remainder man still owns the property. You just did what you were supposed to do. You did your job. Like, that'll do, pig. It's from Babe, if I never saw that movie. Like, you did what you were supposed to do, and that's it. You didn't do anything special. You can't just own the property because you paid for the tax deed. That's literally ridiculous. Why did you say that was so hard, Isa?
Talking about the con law essay that you assigned.
Oh yeah, that essay was so hard, and then this essay I think was even harder, and they were back to back. To be fair, the trust essay that I took, and now they've eliminated trust, I thought was easy. So at least there was that. And me being someone who likes to think positively and just position myself for success, I flipped through the 3 essays, saw the trust essay, and was like, all right, let's just crush this one. Give me some confidence, and then I'll take my best out of the other 2. I kind of believe that. Pick the essay that you know you could write best first and knock that one out of the park just to build up confidence and momentum. Okay. But everyone has, there's different strokes for different folks. You know what I mean? Whatever works for you, I'd be happy to entertain it and give you my opinion. Okay, so, right, she doesn't own it outright. That's ridiculous. I'm an attorney, but they refuse to leave until the 5 years have expired. So now, what does this implicate, this sentence?
Tenancy at sufferance.
Potentially, I would say more that we've identified it's probably not a tenancy for years, it's probably a periodic tenancy, and that implicates the notice requirement. How much notice do you have to give them? She wants to evict them early, they refuse to leave until the 5 years. I think we're going to meet in the middle, and you're going to have to give them, you know, if it's a, what type of lease is it, in my opinion?
Periodic.
And what type of periods?
Quarterly, it says, right?
Right. That's the implication here. You tried to set up a tenancy for years for a 5-year period, but it failed because it wasn't in the statute of frauds. Therefore, what will be implied is a periodic tenancy based on the payments. Since the payments are made quarterly, we probably have a quarterly tenancy. When in doubt, I think a general rule of thumb universally is you're supposed to grant them a period in advance. So maybe they need to be made aware a quarter of the year in advance, but it could be more specific. Like I said, I haven't memorized that today because I'm not taking the test tomorrow. Yeah, quarter is 45 days. Okay, so not actually advance. Actually, now that I think about it in Florida, I think a half a period advance is what you're required, unless it's week to week. But month to month is 15 days, quarter to quarter is 45 days. So half a period is maybe a better rule of thumb. But again, we'll learn about that. So in exchange for reduced rent, the attorney does some shady stuff. We're not going to allow that. attorney gets even shadier. Oh, I have them right in front of me. All right, thanks, Lexi. I appreciate that. So the attorney forgets to pay the taxes due in the first year. We already talked about that. Nancy claims that she owns her property based on tax deed. She wants to evict them, and we talked about how this is going to implicate the periodic tenancy requirements. In the alternative, Nancy demands that Tom and the charity reimburse her for the amount she spent to improve the property. Can Nancy be reimbursed by the remainder men for the improvements she made? Ariane, you want to take it away with this?
I think she can if they give her consent in advance to do that in first place.
Did they give her consent in advance to do it here?
No.
So can she?
Oh, no, she can't.
Exactly. Beautiful, beautiful argument, right? If they would have consented to it, yeah, they're the remainder men. They would be liable for it, but they didn't. This is a merit of waste. If you commit waste on the property, you cannot recover from the remainder men. That's Nancy's wilding. Like, Nancy, you need to chill. All right, Tom claims that he can. Nancy reminds me of Aunt Martha from the cookies. Tom claims that he can foreclose on the property based on the loan to Doug. Okay, what do we talk about that? Can he foreclose based on the loan to Doug? Yeah. I love that you said that term, out of pocket. I think that term originated in my hometown, Philadelphia. The charity wants to avoid the controversies and seek a partition against Tom. All right. Is that possible? Can the remainder?
No.
Who said that?
No, because their rights are not vested yet. They will vest when Nancy dies.
Right. They can't seek a partition as remainder men because their rights have not vested yet. And if Ariane seems like she knows everything about this essay because she's already written this essay and we talked about it, like the people who are stunting on the class it's deeper than you think. Okay, so look, I just want to show you this memo, right? We'll do more issue spotting, but I want to show you how much I love this memo. I think if you don't know how to write a memo and you're still trying to find your voice, write it like this. To, from, date, subject. Couldn't agree anymore. The purpose of this memo is to inform you of each of the parties' interest in property regarding the Nancy's case. Okay, well, maybe I wouldn't have called her the Nancy. The wild Nancy, maybe. The out-of-pocket Nancy. But this is good, right? They do an amazing job. This is what I would do. Set it up. And then if we look at the essay, do you see how they did IRAOC for every single one? IRAOC, IRAOC. They just did issue, rule, application, opposing argument, conclusion, and it reads beautifully. Okay. Was the deed from the woman to Scott valid? Rule. In order for a deed to be valid under Florida law, it must be attested by 2 witnesses, contain an accurate description of land, and be properly delivered. In order for a deed to be properly delivered, physical delivery is not required. Delivery to a third party on behalf of the recipient is enough to constitute delivery under Florida law. Application. In the instant case, the facts do not provide whether or not the deed was attested by 2 witnesses or contain the description of the property. See, we're just going to say we have to assume this, but we're still going to get points for writing about it. More facts would need to be provided. However, the deed in the instant case was properly delivered as the woman conveyed the land through the deed, physically delivered the deed to her sons, Scott and Doug. Upon receiving the deed from their mother, the deed was properly delivered, right? Delivery of the deed, issue, rule, application, opposing argument. The opposition, and this is going to be some trash argument, but at least they put it. The opposition will argue that the deed was not properly executed if it was not signed and did not contain the accurate description. However, if it was not properly executed, the delivery would not matter because the deed would be void on its face. Again, this argument is contingent upon receiving more facts. Conclusion, the court would likely hold, absent any facts to the contrary, that the deed was properly delivered so long as the deed was out on its face. You see how they're talking about something that most people would just take for granted when it said that, she deeded to her, right? I would even done something that he didn't do when it says this is not a homestead property. I would have mentioned why it's important. And he has Scarlett saying they're getting points for doing this. So I totally agree. All right. Next piece. What interest do Doug and Scott hold in the property? In order to hold property as JTROS, 4 unities must be present. Time, title, interest, and possession. This means that the parties taking interest in the property must take the interest at the same time, by the same title, with the same interest in the property and have equal possession to the property. Additionally, specific language must be found in the deed in order to create a joint tenancy, such as with rights of survivorship. Without that specific language, Florida law assumes the creation of a tenancy in common. Right, has to have the specific language with rights of survivorship, has to have the four uses. Application, due to the language in the deed, they hold the property's joint tenancy with rights of survivorship. The mother specifically placed the word with rights of survivorship in the deed and therefore created joint tenancy with rights of survivorship. Additionally, we had time, title, interest, and possession. Opposing argument. The opposition might argue that the facts did not specifically indicate it was delivered to Doug and Scott at the time. However, this argument will fail because it does not need to be physically delivered to both people at the same time to properly convey the JTRS. It must merely convey in the deed at the same time in order to satisfy the requirements. Conclusion, the court will most likely find that the woman validly conveyed a JTRS with rights of survivorship. Doug and Scott. See, they're just cruising through this. They're issue spotting, they're and they're opposing. And so far, the two opposing arguments have been absolute trash, but they've at least gone through the methodical process of coming up with something. I was reading Ariane's essay and it really made me laugh because she was trying to do this. And that's all I can ask for is just trying, trying is the most important thing. And she wrote, the opposition will most likely argue something, but this will fail. And I started laughing because I was like, I get it though, because she was right. There was no good argument the opposition could make, but they would try to argue something. But you know what I mean? Like try to articulate, that they might argue that the facts don't indicate this or that, or that, they would need more facts or something. But I just like the effort of doing an opposing argument. You can't be upset with that. So great job, Ariane. The issue, can Tom foreclose on the property based on the loan to Doug? And Omar had a great job of identifying these rules. A JTROS allows either party to encumber their interest in the land as they wish. This means that either party may take out a mortgage and use their interest in the land as collateral, or may allow creditors to place a lien on the property. However, such an encumbrance does not alter the other party's interest in the joint tenancy, so long as a joint tenancy in a lien theory state. A lien theory state like Florida allows either party of a JT to do whatever it desires with their interest in the property without severing the JT. However, in title theory states, placing a mortgage of property would sever the JT. Additionally, in lien theory states, because an encumbrance placed on the land by one member of the other holder's interest, if the encumbered holder dies before paying back the mortgage on the lien, the creditor cannot collect from the unencumbered holder. Application, due to the fact that Florida is a lien theory state, when Doug pledges the property as collateral to Tom, this did not sever the joint tenancy. Additionally, because Doug did not repay his loan to Tom before he died, his interest passed by right of survivorship to Scott, and therefore Scott owned the entire property in fee simple. Due to the fact that Scott owned the entire property in fee simple and was not encumbered by a mortgage lien or other levy, Tom will not be able to recover from Scott because the debt was not Scott's and Doug did not pay it back before dying. Right, Scarlett's given some great points. This will likely fail, albeit unsuccessfully. Awesome phrases to use. I always use is important to note, right? I love that. It is important to note something that's really not that important to note, but I might get points for it. Okay, in joint tenancies in lien theory states like Florida, debts do not pass with the land. Once the debtor dies and his interest passes to the other holder, the debt is dissolved and the creditor is left without recourse. Opposing argument, here we go. Tom will argue that he's entitled to repayment of loan because the encumbrance on the land severed with the joint tenancy and created TIC. This argument will win if Florida is a title theory state. However, Florida is lien theory and this will fail. Conclusion, Scott owns the property in fee simple and is not encumbered based on Florida's lien theory and applicability to joint tenancies. Excellent, super excellent, right? Time, title, interest, possession, lien theory state won't sever it. The death is actually not, is gonna kind of screw over the lender in terms of recovery. We're clear? All right, is the oral agreement to rent the property enforceable agreement? The sale and lease of the land falls under the SOF and thus must be reduced in a writing to be enforceable. The signed writing must include the names and signatures of parties to be charged, an adequate description of the land, and a sales price is determinable. In the instant case, Nancy entered into an oral agreement with Tom, an attorney, to lease land to them for a period of 5 years and would collect rent from them quarterly. This would be considered a lease of land and therefore falls directly under statute of frauds. Therefore, the oral agreement between three parties is invalid and unenforceable because it's not reduced to writing. The opposing argument. Nancy would argue that statute of frauds is not necessary in the instant case because of partial performance. Great opposing argument. This is actually a good one, right? Hey, what's up, Kitty? See what you said. I didn't mean to knock on cats. I do like cats. I like all animals. The attorneys and Tom had already lived on property for a year and therefore partially performed. This argument will likely fail, however, and the court will require the lease between the parties to be reduced in writing to be enforceable. So that's a good argument. Swap, partial performance. I could hear it. Conclusion, the court will find the oral lease between the parties is unenforceable because it does not comply. So then a great question. What type of lease do they have? They're doing a great job of like, you know, just marching through this. And Omar, I don't know where you're walking to, but welcome you to high today. Okay. What type of lease do the parties have in the instant case? A periodic tenancy is created when parties agree to rent for a set of periodic time with payment set in intervals. In order to terminate a periodic tenancy, Florida has very specific rules. If the tenancy is year to year, the notice must be 6 months in advance. Quarter to quarter is 3 months. Month to month is 1 month, and week to week is 1 week. Again, I think these are wrong. I think month to month is 15 days and quarter to quarter is 45 days, according to what Lexi said. So don't believe everything you read, but just know this is a periodic tenancy and there's eviction notice requirements. In this case, the parties had a periodic tenancy. Like we said, the statute of frauds failed, periodic tenancy resulted. In order to terminate a periodic tenancy, the termination of periodic tenancy, proper notice must be given by either party's terminating. This was not the case in the instant case, therefore they could sue for damages. Conclusion, the court would likely find intent to terminate the tenancy was not properly given in the instant case, right? You can't just terminate them, you gotta give them proper notice. Can they receive reimbursement for the waste? No. 3 types of waste: actual, permissive, ameliorative. Actual is like you punch a hole in the wall. Exploiting natural resources, the owner of the property is not permitted to overuse the resources. I mean, actual isn't always about using resources. It's also about just causing damage. Permissive refers to keeping the land in good condition, right? You can't let it go in disrepair. And then finally, ameliorative refers to waste that improves the value of the land. Here, we definitely have ameliorative waste because you built the offices, and even though it can be able to recover. Opposing argument shall argue that that would greatly improve the value of the land for rental income, shall argue that they benefit from it, and however, she will not be able to recover. You see, weak argument, but she still makes it. The only strong argument I've heard in the opposing argument so far was this one, partial performance. I could entertain that one, honestly. It's not a terrible argument. The rest of them I think are terrible arguments, but you still get points for making them. And I think that's a skill, being able to make terrible arguments. And as a litigator or attorney, you're going to have to do that sometimes because your clients are going to do things that they really shouldn't have done, and you're going to try to represent them to your best abilities. All right, ethical issues we're not so interested in. And then finally, partition. Is a partition available? All they said is super quickly, they're running out of time. They cannot partition the land when Nancy has a life estate and she has full possession. Judicial partition will not be allowed until the rights have vested. So great job, everyone. Did they ever mention the tax deed? Not one single time. Was this one of the best essays I've ever read? I think so. I love how it's issue, rule, application, opposing argument, conclusion. Does anyone else like that or dislike that? You like it? Yeah, I don't think like, for instance, Gabby, I've been working with her and her essays are awesome. I'm going to be honest. She's a really great writer. I wouldn't write my essay like that if I was Gabby because she already has her voice. You know, that style is more for people who are really struggling to put together essays. It's a fine way to do it. I'm not going to write my essay like that because, you know, I have an English major. I like to write. I read poetry, whatever. I like to write in a more, you know, just different style. But that style is perfectly acceptable. And I believe it's the safest style to write in. And if you write in another style, at least make sure you're considering those elements: issue, rule, analysis, opposing argument, and conclusion. Any questions about that? All right, let's spend about 20 minutes, call it a day. We'll do maybe 2, at most 3, quick rapid fire issue spotting. Any years in particular that are of import? I feel like we got to do 2008. That's the year I graduated high school. I would say it's the best year of my life because like graduated high school, then I had summer, then I started college. My favorite baseball team won the World Series. Some good things happened. Okay. So July 2008, real property. All right, let's see what's going on here. What cause of action does investor have claiming title to ranch? What defenses might be raised by brother? And who is likely to prevail? Also, any ethical issues. So we do see, I want to make sure, and I really appreciate you, Scarlett, for sending that. Read that thing she sent up and down. I have my own ethics materials, but make sure you know ethics so well, because it's 100% likely to come up. Probably going to come up twice. Okay. So action between what cause of actions you have in claiming title, what defenses may be raised by brother, and who is likely to prevail. That's like my Hulk Hogan impression. Okay. Partner at your law firm asks you to analyze the following situation. Landlord owned real estate known as the ranch. A year before his death, landowner delivered a deed to his brother, granting his brother the ranch as a gift. Okay, what do we usually think of a gift? Why is gift important? You receive.
No, didn't pay value for it.
So what does that mean?
He's not a bona fide purchaser.
Bona fide purchaser, yeah.
Bona fide, yeah.
Yeah. Don't worry, this test was in Portuguese. I know it'd be a lot easier. I have so much appreciation for people who are taking this test and not their native language. It's tough. I know Isa perked up because I think you're Brazilian too, right, Isa? Yeah, see? Ariana, Isa, you guys can, yeah, Brazilian gang. Okay. A year before his death, landowner delivered deed. So we said that the gift is important because you're not a bona fide purchaser. We think deed is important because maybe deed formalities. It does say that conform with all requirements for valid deed. I'd probably still mention that. I like to mention this comply with all formalities, which means boom, boom, boom. Just do it in a minute and move on, you know? You're probably not gonna get points for it, to be honest. But I still think I would do it as a matter of course. Okay. Desperate for money to pay for medical treatment, landowner contacted investor. Investor was landowner's accountant. Investor suggested that investor be allowed to purchase, I think this should mean lawyer. Accountant suggested, I think I should say accountant. Accountant suggested that investor be allowed to purchase the ranch from landowner. Landowner told investor that he gave the ranch to his brother. Investor checked the county records and found no deed and was recorded. Honestly, this is super convoluted. I got confused as I read it, but what keywords did we see and what issues do we know we could spot?
Recording statute, notice. No notice.
Right, notice, recording statutes. What type of notice jurisdiction is Florida?
Pure notice.
And what does that mean?
BFP takes subsequently, but here
Yeah,
there's no
subsequent
BFP.
bona fide purchasers will prevail, right? So here we know that the brother's not a bona fide purchaser, right? He said that he gave the ranch to his brother. He checked the county records and found no deed. So record notice. What are the three types of notice?
Constructive notice,
Yeah.
actual notice, inquiry notice, and here he had actual notice because the guy told him that he gave the ranch.
Right. So maybe an actual notice here, record notice, inquiry notice. I'm just trying to issue spot here for the end of class, but good job, everyone. We've issue spotted bona fide purchaser, deed formalities, pure notice jurisdiction, different types of notice. Accounting. That was always my least favorite subject in school. Now that I'm a businessman, it's like the most important thing. Investor percent of the ranch's fair market value. At the time of the purchase, landowner delivered a deed to investor granting the ranch to investor. The deed conformed to all requirements of a valid deed. So investor then purchased the ranch from landowner for about 50% of the ranch's fair market value. Why do they mention that? He was desperate for money to pay for medical treatment, and he purchased it for 50% of the value.
Maybe to argue the BFP where the BFP wasn't buying for value.
So yeah, see, people saying non-good faith for good, what that, I'm gonna think of contract claims here, right? Maybe some sort of unconscionability or some undue influence or some, taking advantage. Yeah, exactly. He said the same thing as me, right? Again, I always think unconscionable, but that's contract. Be careful with that because first off, Florida does a terrible job of labeling their essays. I've seen essays labeled as torts that are like all family law. And second off, they overlap. And I think since they've slimmed down the essay subjects, they're going to overlap even more. So I think that's an issue, whether there's some sort of undue influence or maybe misrepresentation or something about the contract as it says. Right, a land sale is always a contract, which would make us think of, statute of frauds and things like that. At the time the deed was delivered investor ranches land to prepare for construction. So what does that mean? Cleared much of the land for construction. What does that implicate?
Waste.
Performance, partial performance.
Yeah, performance, reliance, also notice. Yeah, inquiry notice that he's using the land, right? And if you would have seen it, you would have known. Investor recorded his deed. So this is all going to be about recording. 2 weeks later, brother recorded his deed, bona fide purchasers, landowner died shortly after. During the consultation, investor told partner to be willing to forget that landowner told him he gave the property. So that's ethical issues. So not too much here, right? This is going to be about pure notice jurisdiction, different types of notice and deeds, and maybe defenses, right? The best, when it says defenses, I think the defenses raised by the brother are that he had inquiry notice, because the main thing is the brother's not a bona fide purchaser because he got as a gift. But then the other piece is that the landowner who was received it second should have had notice of it, right? Landowner told investor he gave the ranch to his brother. Investor then purchased the ranch from landowner, right? So the investor knew he had actual notice. There's a whole lot of issues going on here. But I don't think there's too much more than just talking about notice and pure notice and deeds and maybe some contract issues. Let's see what they talk about. So 2008, feeling great. This memo will address the causes of action. See, I love that. That's how I started. It will further address the defenses. Lastly, it will, right, they do exactly what I do. This memo will address the exact questions. Conveyance to brother. The first issue is whether the conveyance is valid. In order for a conveyance to be valid, it must be executed in accordance with the statute of frauds, naming the parties, adequate description of the land, and the signature of the party to be charged. In Florida, attestation of 2 witnesses also required. The facts state that it conformed to all requirements of valid deed, so we can assume this part is met. That's exactly what I said. Even though it says it met with it, we can get points by saying what those assumptions are. Further, delivery element is met, and we can talk about that. The fact that this was a gratuitous conveyance is no effect, and at the moment it was completed at valid title, right? As far as the conveyance, it was gratuitous. The effect of the gratuity is the bona fide purchaser status. The next issue is whether or not this conveyance is valid. Again, the fact states that it was a valid deed. However, it arose from a contract for 50%. There are a couple of issues which are amplified here. Undue influence, that's what I was saying, right? So great point. Property is just contract law. Like my uncle is a construction lawyer, but he's a contract lawyer. What he would tell you he does contracts, but he only does contracts in the realm of real property, specifically in the realm of construction. So it's like contracts is kind of a big web. And you see there's like UCC, common law, and then there's real property law, which is like a type of contract law. There's also secure transactions, commercial paper. In my mind, those are all types of contracts. So kind of understand contract claims can be brought, especially if it's not in the deed, it's in the contract. Here, undue influence, we talked about, fraud, misrepresentation, we talked about, unconscionability. Great job, Issa, amazing. You all understand that, right? Like we spotted those issues. Okay. On the notice statute, this is what this essay really was getting towards. At common law, such multiple conveyances were settled by first in time, first in right. However, Florida is pure notice. That means regardless of who's first in time, will protect a subsequent good faith purchaser for value, so long as they took without notice. In order for investor to prevail, he must seek protection under the statute. In order to take without notice, they said, if he is able to seek protection here, he'll be able to prevail. It'll be a difficult hurdle to cross because they will argue that he took with notice and that he was not a purchaser for value. In order to take without notice, they must have neither actual inquiry or constructive notice. Actual means they actually know. Inquiry means that a reasonable inquiry would have saw, and constructive notice is recording. Florida creates where proper recording. Okay, here's a good sentence. In Florida, whereas proper recording is constructive notice, a lack of recording creates a presumption of no notice. The burden is on the prior purchaser to show actual notice. So they must show they actually knew. And as I think Omar stated, the facts state that he literally told him that he didn't give in fact notice. He could introduce evidence if El told him this. Florida's abolished the dead man statute. Don't even worry about that. I'll talk about that when I do evidence. Additionally, because the accountant-client relationship, I mean, privileges, I'm not really involved in this, inquiry notice, right? That's what you're gonna say. You had inquiry notice because they prepared the land for construction. So you had actual notice, you had inquiry notice, and then he'll say he wasn't a purchaser for value. You guys did make this point because you only paid 50%. However, as I responded, you probably were for value, even though it's not 50, even though it's not full, it's not the amount of the value, it's just were you for value. So although investor recorded first, because the court is likely to find that he was not a bona fide purchaser, either actual inquiry notice, he will not take protection. The effect of him not falling within the statute is that his subsequent purchaser is not protected and we technically fall back under the first in time, first in right, and B's interest in the property is protected. This is regardless of the fact that he did not record until after I. However, if I were to attempt to convey the land again, anyone conveyed to would not be a good faith purchaser because B's subsequent recording now yields constructive notice to any future purchaser. They're getting into the weeds here, but they are saying that, like, yeah, anyone in the, there's no possibility of there being a future bona fide purchaser because the idiot who had inquiry and actual notice recorded. So now it's like there's so much notice on the record. So conclusion, there's strong arguments anyway, but he has no protection because he had notice. And then the ethical considerations. You see, like I said, there could be a whole landlord-tenant essay. There could be a whole essay just on notice. And I think writing about notice is a tough thing. You got to make sure you can write about actual inquiry, constructive, and you could talk about what it means to be a bona fide purchaser. Let's just do one more. Anyone have any questions about that one? All right, let's pick a year. That's really property like. I think going back in time is always good. 2003. All right. Let's look at this one. 10 years ago, homeowner purchased some land besides a river and built a house. Homeowner purchased the land from boater who had owned the land from the previous 15 years. During those 15 years, boater never developed the land, but instead used the land on a regular basis for hunting and fishing. City recently built a bridge across the river adjacent to homeowner's property. What do we think this is talking about right here? Maybe built a bridge. What does a bridge usually mean? Yeah, easement, water rights. I did something I don't usually do. Let's see what that thing says. Prepare an opinion discussing the following: homeowners' potential legal claims against the neighboring city, potential defenses by neighboring cities such claims, and the legal outcome of homeowner against neighboring city. So we have homeowner versus neighboring city. So the homeowner purchased the home and he built a house. He purchased it from a boater who had owned it for previous years and it was undeveloped. But the city recently built a bridge across the river adjacent to the homeowner's property. So you're right, nothing really implicated here, just background information. Prior to the construction of the bridge by the city, the only way off of homeowner's property was by a small road that cuts through neighbor's property and leads to a major highway. What does that implicate? Someone's saying prescriptive easement, but I think maybe a different type of easement. The only way.
By necessity?
Yeah, easement by necessity, right? So major highway, easement by necessity, prior to construction of the bridge. Homeowner regularly used this road during the past 10 years to gain access to homeowner's property. Prior to homeowner, boater had used the same road for 15 years. Okay, but now, Scarlett, restate what you just stated, because now I think it's relevant. Okay, excellent. Prescriptive easement, right? Now, why would they be giving us these years? If they're ever giving you years in property, it's either adverse possession or prescriptive easement, right? So they're trying to talk about prescriptive easement. Yeah, SOL, statute of limitations, not smack out of luck. Okay, so recently the neighbor and homeowner have gotten into dispute unrelated to the use of the road. Neighbor has known about homeowner's past use of the road. Neighbor, however, has become so upset by the dispute that they constructed a fence blocking homeowner's use of the road. Although the bridge has now provided homeowner a new way to exit homeowner's property, homeowner must drive an extra 20 miles to travel to the city as compared to the much shorter route if homeowner uses the road through the neighbor's property. What is this all talking about? Spite fence, torts, maybe. Nuisance, maybe. What else though?
He was trying to terminate the easement by putting the thing there.
Exactly, termination. So Can you terminate someone's easement by necessity? No, but do they have an easement by necessity here? When the necessity ends, right? They don't really have an easement, Hannah. Why don't they really have an easement by necessity here? Why would you argue?
It's just saying that they have to drive an extra 20 miles, not that it's the only way out.
Right. So that's, again, opposing argument is that there is no, the necessity is ended. The opposing argument is, well, you still have to drive 20 miles, so it's unreasonable. But I'm like, easement by necessity is supposed to be by necessity. The opposing argument, right, is that maybe you've acquired a prescriptive easement here, right? Because if you've been doing it, but again, that argument probably failed because that would have to be adverse. It has to be for, we said 20 years. I just don't think we see it. But why do they say prior to homeowner, boater had used the same road for 10 years?
Tacking.
Tacking, right? Does everyone recognize the tacking? 10 plus 15, 25. So maybe there is an argument for prescriptive easement. This is all about easement by necessity, prescriptive easements. The new bridge also blocks homeowners' view of the river. Do we have a right of a view in Florida? We don't, right? Build your house touching the water. Go live on Stiltsville if you want to see the water. The value of homeowners' home was reduced from 300 to 200 because of the bridge. What is that?
Takings by the. Never mind. I don't know.
Maybe, yes, takings. Absolutely. Because they constructed a bridge and the bridge reduced the value of their property. Definitely an argument for takings. Argument also for potentially nuisance, maybe. Weak argument. I think the best argument here is that you don't have a view of the river, but you may have an argument for the diminution of the value of your property as a takings. Maybe. Probably fails because you don't have a right to your view, but it's a decent argument. So he has the claims for you. Let's see what we got here. First off, professional conduct. This is a great thing to do. Take Scarlett's letter. Scarlett's letter. Hilarious joke. Take Scarlett's letter and see if you can learn a lot about ethics and then dump that at the beginning, right? This is all about contingency fees and, basically you can't take a contingency fee in domestic disputes or crimes, and it has to be calculated and you have to have consent from your client beforehand, things like that. But look, eminent domain and inverse condemnation. That's exactly what someone said. Is this an eminent domain or inverse condemnation claim? An easement can be expressly or impliedly acquired. It may be given in deed, obtained by necessity of use, or acquired through adverse possession, also called a prescriptive easement. Here, there's no indication that the easement was written into a deed or that NH owned their property from a common prior owner, so it's likely that would not be considered express. On the other hand, the easement was a necessity and that prior to the bridge being constructed, it was the only way off the property. N would argue that H could still make a boat to leave the property, but the court will have to determine whether or not that is reasonable. A landlocked property is always granted easement by land necessity, but the owner of the asserving estate usually be able to choose a reasonable location for the path across his property. The dominant estate, the one obtaining the benefit of the easement here, may not claim the use due to its convenience when a viable option is available. Exactly. So here, N would argue that the 20-mile deviation is not so excessive that he need retain the location of the easement's property. H would argue that he didn't abandon the easement and that N has not yet reasonably relied on such abandonment to justify revoking the passage and erecting a fence to block H's egress. Told you, this would be an argument both ways, right? Like, is it still an easement by necessity or not? One thing, and this is an MBE question answer, easements are affixed to the location. Like if something changes, you can't move the easement to the other side of the property. It's affixed to the part of the property that it was at. Also, the characteristic of the use of the easement has not changed. There's no plans to expand or widen the road or bring in higher traffic. So H can argue there's been no additional burden. N might contend that the city's erection of the bridge across the river would increase recreational tourist traffic and whatever. Should these arguments fail, H will claim that the parcel uses prescriptive easement. You see, they did exactly what I said. The first argument is that's an easement by necessity. You're probably going to lose that argument because it's no longer necessary. But we're going to argue it really thoroughly. Then once that argument fails, we're going to jump into the prescriptive easement. And we said it. It's 20 years in Florida. but they could potentially tack on to make it 25 years, thus satisfying it. Although he knew about it, he did nothing about it. He would argue that he did it open with his knowledge. However, if he gave him permission, it wasn't adverse. That's what my argument was. So although you have the 25 tacking years, they're saying therefore the easement likely remain open as one acquired by adverse possession, so it probably prevail under the facts. It all come down to me whether it was with permission or not. He says, as he did it in the open, not in secret, he held exclusively despite his ownership. It really came down to permission or not, but there's definitely, it's all about issue spotting. They wouldn't have given you 10 years and 15 years if they didn't want you to add them together. And if you added them together, they wanted you to write the word tacking because that's the legal terminology. It's like if you give a mouse a cookie. If they give you land and they give you years, it's either going to be adverse possession or prescriptive easement. Okay, that next, whoever said this was great, talking about the takings. So is there going to be a takings? Let's see. In general, there's no right to light, air, or aesthetics. Therefore, being deprived of these rights does not constitute a cause of action, which can be constituted. Here, agencies claims on these grounds would fail. When the government institutes a regulation that has the effect of a total deprivation of the value's property, it will be seen as a taking. In the present case, it's not a total deprivation. It's just a 1/3 diminution. And there's some claims back and forth, but doesn't really matter. Should the court decide that as a riparian owner, he's entitled to a view, which they won't find, then they award compensation. However, that claim will probably fail, right? There was nothing on there that we didn't see or didn't note. Just to end class, I'm just gonna pick one more and just breeze through it in 2 to 3 minutes, and then we'll call it a day. And that'll be that. So let's pick October 2020. Do you know why this test was administered in October?
Okay.
Yeah, once upon a time, many years ago, in the world far and far beyond and away, we all had to wear masks and we weren't allowed to see our friends, and we had to take tests virtually. And that was a nightmare. It was scheduled for July. We're not pushing it back. We're Florida. Okay, fine. We're pushing it back to August. Okay, we're not prepared. We're going to push it back to October. It was a nightmare. And that's really what happened. So this one, it says real property ethics. It seems to be about, promissory note, mortgage on a property, a home. I think it's probably going to be a homestead potentially. It talks about recording and a deed, joint checking. So Hank and Willa, I'm thinking that it'd be JTRS or tenancy by the entirety, gambling. So this is a family law one, kind of. When I told you, these are kind of mislabeled. But remember, it's like if you're married and you do things that are not for the marital property, maybe you won't be liable for it. But it also talks about this is all family law. But let's see what the real property issues are. Mortgages, deficiency judgment. Remember deficiency. Remember foreclosure. All these hard words. Let's see what happens. Respective interests, outcomes, whether they can reach it, and the defect of a divorce. So this will kind of foreshadow family law, but it also talk about some key things, right? Remember homestead exemption. If you don't know sunshine law and homestead exemption, take the UB, right? Florida law, you got to know homestead law and sunshine, homestead exemption, sunshine law. So here they talk about homestead. They talk about deed formalities. We've definitely brought this up many times today, that the deed has to be in writing, signed by the grantor, reasonable description of property, name the grantee, and most importantly, 2 attesting witnesses. So we talk about the deed and the delivery. It has to leave their hands and be out of their control. So fee simple absolute, it's just a type of fee. Tenancy by the entirety, again, T-tip, no straw man is required, JTROS, plus marriage, all those things. This is the one we probably looked at the outline, and now you're seeing how it's written. Florida presumes that a person who receives a property takes subject to a mortgage on the property if the deed is silent. And then we talked about subject to versus expressly assumed. So he's subject to the mortgage. And then he offered to buy the home and the foreclosure. They may foreclose on a property when the underlying obligation to which it relates is in default, typically due to a failure to make payments. So it talks about a mortgage. To foreclose on property, Florida requires the plaintiff to show standing. He must show that he's the owner of the note and obtain ownership prior to foreclosure action. Ownership may be proven through an unbroken chain of self-authenticating assignments. he must also name the parties to the foreclosure action. So foreclosure action, homestead protected from the for sale, huge point. However, homestead does not apply to liens that are attached before the homestead protections were created. It does not apply to mortgages incurred for purchase or improvement of the homes. So he'll be successful in the homestead action. Foreclosure of a senior interest at a judicial sale eliminates all junior interest on the property, so long as notice is given to the junior interest, right? Junior interests do have a right to be at the foreclosure sale. Whether an interest is junior or senior is determined by first in time, first in right. Again, PMMs will always have senior priority, as we see down here. Florida allows for deficiency judgments if the foreclosure of the mortgage property is not enough to cover the amount. The mortgagee may recover the deficiency. Here, since the foreclosure on the home is not enough to cover the 200, Luis will be able to recover the rest from Hank. Luis will not be able to recover from Wilma since she took subject to the mortgage. Purchase money mortgage, when the loan is used to purchase the property. Here, he used the loan to purchase the property, thus they have a PMM. Homestead is protected from forced sale from creditors, unless it's one of those exemptions we talked about. One tenant may not encumber property that is held as a tenancy by the entirety without consent by their spouse. And then it gets into divorce. A divorce terminates a tenancy by entirety and creates a tenancy in common. And then ethical issues. So the one type of essay that we didn't really look at today, but I want to just make sure that everyone is aware of, is that landlord-tenant issue. So definitely on your own, go through, and I encourage you should go through all the at least past 10 years, every issue ever written, and read the essay and the answer and make sure you're familiar and comfortable with it. The one type of essay that we didn't really get a chance to go over is that landlord-tenant issue where, you have the tenant from a bad place and the landlord from even worse place. The landlord's not doing his duties, the tenant's not doing their duties, quiet enjoyment, habitability, constructive evictions, holdover tenants, all those different concepts come into play on a landlord-tenant essay. So just do make sure that you feel comfortable and confident writing those essays. Someone's talking about a hurricane. Someone made an inside joke that we didn't wear masks in Florida. I think you saw the governor DeSantis, he put the mask on incorrectly. So we have issues, but we still are a state that has no state income tax and pretty good weather. So lots of good things going on here. I hope everyone enjoyed today's class on real property. Can't stress it's a very, very important topic and it demands your attention. So thank you all so much.